Hello, my name is Colton Fehr, and I'm an assistant professor at the Faculty of Law at Thompson Rivers University. I'm here today to say a few words about my new book, Constitutionalizing Criminal Law. And constitutional law scholars have long debated whether courts should be able to strike down laws, a practice known as judicial review. And in Canada, we endorsed this practice under the Constitution Act 1982. A question that has received scant attention, though, is the one I address in the book. When a law violates multiple rights, as unconstitutional laws often do, which type of right should judges employ? This question rises at Supreme Courts in particular because these courts, quite rightly, tend to decide legal issues in as narrow a manner as possible. They do so not only for efficiency reasons, but also to maximize the amount of time they can spend arriving at the best possible answer under the right with which they choose to strike down a law. And under the Canadian Charter of Rights and Freedoms, there are three main categories of rights relevant to criminal law. First, there are rights specifically enumerated in the text of the Charter, such as the right to equality, freedom of expression, and the prohibition against cruel and unusual punishment. In addition, Canada adopted a general right under Section 7 of the Charter not to be deprived of life, liberty, or security of the person except in accordance with the vague-sounding principles of fundamental justice. In interpreting this latter phrase, the Supreme Court has constitutionalized various principles of moral philosophy, typically taken from criminal law theory. And in addition, the court has constitutionalized several principles of what they call means ends, or instrumental rationality. And these principles determine the objective of a law, and then ask whether the law applies in an unduly harsh or irrational manner. And in the book, I argue that there are trade-offs when employing each of these categories of rights. When courts use enumerated rights, they act in the most legitimate manner possible because they rely on the specific language of a right enacted by the polity. Unfortunately, the Supreme Court has rarely chosen to strike down a criminal law using an enumerated right over the last few decades. Instead, it has employed Section 7 of the Charter, and one of the main purposes of the book is to uncover why the Supreme Court has preferred Section 7 review over enumerated rights. And in my view, when courts constitutionalize principles of criminal law theory as principles of fundamental justice, they seek to create a clearer understanding of the framework underlying the criminal law. And this has the potential to add coherence to what is an underdeveloped and often confusing Canadian criminal code. However, this approach to judicial review also allows judges to impose their favored principles of moral philosophy as a means to strike down laws, principles that were typically not even considered by the drafters of the Charter. So this approach is therefore controversial for those who think judges ought not have too much power to strike down democratically enacted laws. To counter these criticisms, the Supreme Court began assessing the constitutionality of criminal laws under Section 7 of the Charter based on each law's instrumental rationality. By declaring a law unconstitutional in this way, legislatures are typically able to reply to Supreme Court decisions by either clarifying their objective or adjusting the law's scope. And this approach tends to facilitate what we call dialogue between courts and legislatures, and therefore provide legislatures with much more say on when a law is constitutional, which in turn can quell legitimacy concerns. On the other hand, if Supreme Court decisions may be sidestepped by legislatures, say making nominal changes to a law's objective or scope, then the rights of Canadians will often remain unclear even when a law is struck down. To increase both the fairness and legitimacy of judicial review, I argue that the Supreme Court needs to reverse course when determining which rights to employ when striking down a criminal law. Rights decisions should be based on enumerated rights where possible, the principles of instrumental rationality abandoned, and the principles of criminal law theory invoked only when an unjust criminal law cannot be challenged with an enumerated right. In my view, this approach strikes the most appropriate balance between the need to ensure the legitimacy of judicial review and allow courts to develop the criminal law in as fair and coherent a manner as possible. So in closing, I hope you will give my book a read, and if you do, please feel free to reach out to me as I'd love to hear your thoughts or questions. Thank you very much for listening.